morning.
Good morning.
Particular previous issue parties would like to raise?
Mr. Chairman, not on behalf of the claimant. Thank you. Good morning.
La demandada?
No, señor presidente, buenos días.
No, the respondent has nothing to add.
Can-
Can I proceed? Okay. Good morning, good morning, everyone. Distinguished members of the Tribunal, it's an honor to be here. I have been asked to provide a brief summary of the two legal expert reports that I have submitted. The first one dates from December 2018 and is an Exhibit C 21. The second one is from June 2019. C131. Just a brief overview of my qualifications, who are in Exhibit E2. So I'm a professor of public international law at the Graduate Institute of International and Development Studies. I also teach here at Georgetown University Law Center as a visiting professor, and I have experience in both trade and in investor-state arbitration, both as a litigator negotiating, working in the Secretariat, and I have published quite a bit on trade, but also on investment matters. I've been retained by Hogan Lovells. I've never been retained by them before, and really my opinion, what I will express here is completely my own, my independent expert opinion. So the question that I have been asked to examine is whether the state, the Dominican Republic, has consented to the UNCITRAL arbitration initiated here by claimants. I will go through that question in three steps. First, I'll discuss a couple of background rules on state consent to arbitration, which I think are useful here in this proceeding. And I will then explain why, in my view, consent has been given to arbitration here pursuant to Article 13, both based on Article 13 itself and based on Article 13 and the party correspondence. And then secondly, finally, but really only in the alternative, I will say a few words on why, if any doubt remains in the mind of the tribunal, in my view, consent is confirmed if you read Article 13 together with the MFN clause in the FTA. So a couple of background rules. The elements that I have looked at to see whether there is consent in this case focus on the treaty, the CARICOM DR Free Trade Agreement of 1998. And I want to really highlight this. This is not a bilateral investment treaty. This is a free trade agreement. Secondly, the party correspondence. And finally, and this is relevant under the MFN assessment, other investment-related treaties concluded by the state, in particular here with France and Panama. The benchmark I have used to evaluate whether there is consent here is twofold. On the one hand, obviously when we look at treaty text, the Vienna Convention on the law of treaties and the articles in there on treaty interpretation, and then to see whether there's consent to UNCITRAL, in particular, the arbitration rules of 1976. So when we look at treaty clauses, when I looked at them, my guideline was to look at the text of the clause, the ordinary meaning, to interpret it in good faith, look at the context and do so in the light of object and purpose. Obviously, when there's ambiguity left, we can look also at the supplementary means, in particular the preparatory work and circumstances of its conclusion. Some more standard rules on treaty interpretation, and I think really the standard rules apply here, which is a very important element to stress. In multiple cases, and I think this is the opinion that also I hold, when we look at a treaty, irrespective of the treaty provision we are looking at, and in this case we are looking at the dispute settlement provision, those provisions have to be interpreted like any other provision. I don't think there's a presumption either way. It shouldn't be interpreted restrictively. The state may argue this, nor should it be interpreted in a liberal fashion, which the claimant may want to push for. So neither a restrictive interpretation nor a doctrine of effet utile to really get at consent no matter what. So a very neutral, standard way of interpreting the treaty, also for dispute clauses. Now, when it comes to the UNCITRAL rules, the text there, the threshold, the element required there is to find some agreement in writing by the parties that they wanted UNCITRAL rules to apply. That is a threshold in my opinion. Some further elements. So consent must be agreed in writing. That's what UNCITRAL and also the Vienna Convention require us to find. Standard rules apply. Consent, and this is important in my view, consent can be explicit but can also be found by implication. What do I mean by implication? You don't have to find the actual word consent in the treaty provision. There may be language that clearly implies consent to arbitration. Another element under little 4 here, and this is, I think, also very important in this case, consent can be found in one single instrument, but it can also be found in a combination of instruments. So, for example, in the treaty and combined with the notice of arbitration, or in the treaty Article 13 combined with Article 3 on MFN. And these documents expressing consent may be different, may be distinct, and may be concluded at successive points in time. So I'll be referring also to party correspondence, which may be an element confirming the consent. And then finally, to the extent there's facts involved in this assessment of state consent, and I do think we here do have some factual assessments to make, the party correspondence, perhaps statements of the ambassador yesterday. So there, in my view, the claimant has the burden of proof and must prove facts by preponderance of the evidence. So there's no lower standard, or as we may find in international criminal law, a higher standard. It's a standard, the basic standard of preponderance of the evidence. So let me move now to the first conclusion that I reach, and this is based on Article 13 of the FTA. Looking at Article 13, paragraph 1 of Article 13, in my view, there can be little doubt that in this provision, the Dominican Republic made a binding unilateral offer of consent to international arbitration. The words are clear. The disputes identified shall be submitted to international arbitration. This is clearly one of the options. Shall be submitted. As I mentioned just a moment ago, the word consent is not mentioned. Now, this is an example, and I'm quoting here from an UNCTAD study, where UNCTAD, I don't think UNCTAD is known to be particularly favorable to investors or claimants, but UNCTAD explicitly stated that some BITs, or our treaty here, do not specifically mention consent, but formulations to the effect that a dispute shall be submitted to the center leave no doubt as to the binding character of these clauses. And the idea that shall be submitted really is a binding consent to arbitration, is confirmed in a number of cases as well. The Spanish version, I think, is equally clear. Serán sometidas. Yesterday there was some debate on the 3 options available. I'm happy to enter into that debate as well. To me, it's clear that if you have 3 options, those are 3 options. 3 is better than 1. And I don't see anything in the text there that would require you to first go to one or the other before you can go to international arbitration. To me, the language is, at this stage, very straightforward. Shall be submitted to international arbitration. Now, an element that that I... Sorry, please.
Sorry, sir. I just have one very simple question. Do you speak Spanish?
I do.
Okay, great.
Yes.
Thank you.
Well, I understand Spanish and I read it. I don't feel very comfortable speaking it, but I do understand it, yes. So an element that I consider important in the text is that the disputes defined as covered by the jurisdictional clause here are disputes between an investor and a party. But the disputes are very limited in scope. They are only disputes concerning an obligation of the state under this treaty. So it's a one-way street. It's only obligations of the state that are covered by this dispute resolution clause. The four conditions I see in this provision that are required for the provision to be triggered, for the consent to be triggered, is a personal scope, investor, host state, material scope, as I just identified, no amicable settlement, and then a 3 months waiting period. Now I underline, I think the scope of the disputes covered is important, because to me that implies that only the investor can be claimant. I don't think the state will sue itself, because the disputes listed, covered here, are disputes to be filed against the states. Because the only thing that can be at issue is an obligation of the state. Hence, and obviously it's not explicitly there, it doesn't say the investor can choose, but I don't think this is needed here because the investor is the only possible claimant here, so it's for the investor to decide to go to national court, to go to national arbitration, or to go to international arbitration. And this is merely because of the types of disputes covered. I have not been pointed, I'm not aware of any relevant court or national arbitration proceeding. As a result, the option of international arbitration was picked and is the one that triggers the state consent. Now, it's interesting to compare the language in the treaty here to the CARICOM-Cuba FTA, which is similar but not exactly the same. And it's different in a very important respect, in that the disputes covered under that jurisdictional clause are much broader. They are disputes concerning an investment of the latter. So it could be disputes under domestic law, under contracts. It could be disputes going in either direction. And in that kind of clause, it's explicitly stated that either party may submit. I think in the clause at issue here, this was not needed because of the type of disputes covered. Now, the second paragraph, of course, is very important. So in my view, the first paragraph has provided state consent. A forum has been chosen, international arbitration. If I read the second paragraph, and it requires attention, it requires careful analysis, in my mind, I split it up in 3 different parts. The first part is important because it says where the dispute is referred to international arbitration, which is the case here. Claimant, by notice of arbitration in 2018, referred the case to international arbitration under para 1. So the dispute is referred to. To me, that implies that it has already happened. State consent precedes it. The case is now referred to arbitration. The second part has the famous may agree language in it, but the way I read it, this is merely an optional provision giving the option to parties to either go with one arbitrator, a sole arbitrator, or a tribunal. It says may agree. The third part of the provision, the way I read it, refers to the appointment rules. How will the arbitrators be appointed? What are the applicable rules? And there, the third part, which in the Spanish version is preceded by a comma, the third part, in my view, provides for an option. Either special agreement to go for ICC appointment rules or Stockholm Chamber or any other rules that may be agreed upon by the parties, or establishment under UNCITRAL. And that is why, and again, the word default is not there. But on my reading, the only specific rules mentioned are UNCITRAL. Special agreement is in case special agreement can be reached. If not, we fall back on UNCITRAL rules. So to me, that is the good faith textual reading of this provision. And as I said, in the Spanish version, we see the famous comma, which I do think is important, splitting up the second from the third part. Now, what happened in this dispute? And again, this is key. It can be debated what the default is, and I've given you my independent view. But when I look at the text here, and I then carefully analyze the correspondence up to May 2018 includes emails, letters, where the parties agreed to the establishment of a tribunal. At no point did either claimant or the state express a willingness to go for a sole arbitrator. The notice of arbitration already appointed one arbitrator. So by definition, claimant apparently wanted a tribunal, and then the response, it took a while looking at the correspondence, but the response at some point, the state appointed its arbitrator, which in my view implies an agreement for a tribunal, not a sole arbitrator. Now, in that same correspondence, a debate was engaged as to which rules would be applicable. And in my view, there's a letter by respondent by the state to the PCA, which clearly discusses the rules. And there was a debate as to whether the PCA should be the appointing authority in case the state fails to appoint its arbitrator. And in that letter, there's a clear statement saying, in our view, the UNCITRAL rules of 1976 should apply, not those of 2010. So I take that correspondence, and to me, it fills the gaps identified here in the sense that we have party agreement. We have party agreement on a tribunal and the UNCITRAL rules. We may not have party agreement exposed on international arbitration, but in my view, that substantive agreement to international arbitration is in paragraph 1. Now, even if this correspondence leaves doubt, if I just look at the text of Article 13, paragraph 2, as I said, I have not seen any agreement or proposal for a sole arbitrator. There's not been any special agreement on other rules. When I read the text, in particular the third part of paragraph 2, no special agreement concluded, hence we fall back on establishment under UNCITRAL. And in my view, respondent is correct. The applicable UNCITRAL rules are those of 1976, not those of 2010. And if we look at the UNCITRAL rules, which in my view is the default, in the absence of special agreement, Article 5 of those UNCITRAL rules, which talk about a situation where there's no agreement on number of arbitrators, make it clear that the default is 3 arbitrators, as happened in this case. So we have a forum selected under paragraph 1, international arbitration, and we have a tribunal in place based on party agreement, and by default, following the UNCITRAL rules, 3 members. Now this, what to me looks like an obvious reading of the text, is exactly what the 2 co-arbitrators put to parties upon their appointment, the 6th of June, where in a letter to both parties they say, or they ask whether the parties have decided on special procedures or whether UNCITRAL arbitration rules will be followed. Now to me that is exactly what Article 13.2 provides for. Will there be special agreement or will this case proceed under UNCITRAL? Now I know that the state has taken a different view. And in the state's view, the language of Article 13 does not include ex ante consent to arbitration. the state reads this provision as saying, whenever a case arises, notwithstanding whatever Article 13 may say, for each specific case, the state still has to agree ex post to uncitral arbitration. In my view, this is not in line with the Vienna Convention rules of treaty interpretation. I go back to the basic text. If I understand it correctly, what the state is saying is those two words, may agree, in the second paragraph, they control everything. And they condition not only the second part of paragraph 2, the choice of will we have a sole arbitrator or 3 arbitrators, but they condition even the first paragraph. They kind of neutralize the shall in the first paragraph. And they also apply to the last part of the second paragraph, even though we have special agreement mentioned already there. So in my view, that reading, that very expansive reading of may agree, to apply it all of a sudden to the whole of Article 13, conflicts with the first paragraph. And I use the word conflict carefully. And when we interpret a treaty, we have to give meaning to all of its elements and find a consistent way to interpret the different parts. The may agree, to interpret the may agree as requiring ex post consent, even to international arbitration, to me that's not in line with the first paragraph. And there is a meaning to be given to may agree that makes sense of the whole provision, and that is, as I mentioned earlier, a purely optional. May agree. They may not agree on 1 or 3 arbitrators. If you ask me, what the state is doing is replacing shall in the first paragraph with may, and in the second paragraph they replace may with shall. And that's not what the treaty says. So the other thing that confuses me when I think about the reading of the state is that their reading in many ways duplicates and nullifies the special agreement in the third part. Because if may agree already applies to the last part of the provision, why would they have special agreement in there? It's a duplication. And as I said earlier, I think the may agree to apply to everything reads the comma out of the Spanish version. And finally, looking a little bit beyond the text, and that's what I also mentioned in my report, I cannot stress it enough, this is a very deep free trade agreement. This is not a simple BIT. This text is huge. It's incredibly important politically and for many reasons. The DR and Jamaica have concluded BITs with ex-ante state consent. Multiple treaties, 11 with ex-ante state consent. To me, it would be a little odd not to have the same in a treaty that is supposed to be deeper, more of an integration within the Caribbean region. Of course, this is not decisive proof, but it's a contextual element that I think is interesting to consider. We have statements on the negotiating history that may be useful to look at. And then, as I said, we need to look at the third paragraph, the fourth one even, to make sense of this. And if I look at the third paragraph on diplomatic protection, and I have it up here, what this says, and it's a very common paragraph to see in dispute clauses, is that diplomatic protection is neutralized as soon as the investor consents to arbitration. Now, on my reading, this means that it's enough for the investor to file the notice of arbitration to neutralize diplomatic protection. That implies that the state's consent to arbitration has already been given. Because if you continue reading paragraph 3, it says, so here the state, the claimant has filed the arbitration, it has consented to the arbitration. If you read paragraph 3, this means that there cannot be any diplomatic protection by Jamaica until the DR would have failed to abide by or comply with the award. So all of this language, it presupposes that the mere filing by the investor, consent by the investor, triggers the whole case. It implies that consent by the state has already been offered in the treaty itself. Now, point number 7, I more recently looked at the preparatory work, and in my view, none of that changes my conclusions, and I'm happy to come back to that at a later stage. So, a last point, if this would have been a treaty where ex post consent is needed for each and every dispute, I think the drafters would have written this very differently. There's plenty of examples where you have that kind of ex post consent requirement. This is an example from a Sweden-Yugoslavia treaty, and there it's clear, it shall, upon the agreement by both parties, be submitted for arbitration. Remember, the language here is, shall be submitted to international arbitration, and then there's a provision on appointment of arbitrators, so it's very different. And paragraph 3, 4 continue on the assumption that we have a tribunal in place, that international arbitration is proceeding merely when triggered by the investor, assuming the state has already consented. So that gives you a sense of the FTA we are talking about. This is not an FTA between CARICOM and the EU or the US. This is an FTA between CARICOM and another country within the region, the Dominican Republic. This is a deep integration agreement where, as I said, you would assume that, if anything, they would even be more inclined to agree to investor-state arbitration. And this is also in my report. There's plenty of other treaties where both parties have, in BITs, agreed ex ante to international arbitration, both in BITs and in FTAs. Now, ICSID isn't mentioned in our treaty here, in my view, for the obvious reason that the Dominican Republic is another party to ICSID and hasn't been. So let me turn, sorry, please.
Do you have 4 minutes?
Okay, so let me turn finally, and I'll do this more quickly, to my last point. I think the text of Article 13, the correspondence, is clear. Now, if there's any doubts left, I think it is useful to look at the MFN clause in this dispute and to read Article 13 together with that clause. The clause, in my view, is broad. It refers to areas related to MFN. There was a question on this yesterday. It's also one of the first things I went looking for. Is there an appendix excluding certain MFN issues? There is none. The parties were very careful to not apply MFN to other free trade agreements, to taxation agreements. They had the opportunity to say we will not apply it either to BITs. They didn't. BITs are not excluded anywhere. Another interesting element, which is a provision I have not often seen in investment treaties, there's an Article 8 that implies that includes a very strong commitment to provide appropriate means and procedures for asserting claims and enforcing rights. That is another explicit provision in the treaty here that deals with dispute resolution. This is an area related to MFN mentioned in the treaty. To me, that confirms that in this treaty, dispute clauses are covered by MFN. So ultimately, if there is doubt, in my view, the state consent can be found when looking at Article 13, the party correspondence, the shall word there, the MFN clause, which makes it clear if the Dominican Republic later on does something more favorable in any of the areas listed in the treaty, that can also go to claimant. And then the Dominican Republic, 1 year later, did exactly this. In a BIT with France, it included a dispute resolution clause where I think even the state agrees that there is clear ex ante consent to UNCITRAL. So if you combine those three pieces, in my view, there's no doubt left that there is state consent in this dispute. Now, my reliance on MFN here is an argument in the alternative. It's just to confirm UNCITRAL. Unlike in the cases that were mentioned yesterday, this is not an attempt to change UNCITRAL into something else. It's just to confirm UNCITRAL. To me, the MFN clause is part of the evidence of state consent. There's no question here that claimant is claiming breach of the MFN clause or invoking a direct substantive application of MFN. MFN is just a clause that is evidence to find state consent. The final really important point is, in this dispute, the MFN clause wouldn't be importing consent. The consent to international arbitration is in paragraph 1 of Article 13. The only thing MFN would do here is that it would improve the exercise of a pre-existing right. And this is also something the state, in its submissions, agrees an MFN clause can do. So the beneficial treatment goes to claimant in this case, not because this tribunal would find a breach of MFN, or not because the proceeding here was triggered. The more favorable treatment was automatically awarded to claimant in 1999 when the DR concluded the BIT with France. I will leave these slides for later perhaps, only to conclude with a couple of points on the two cases that were submitted late in this proceeding. Hameson is in a way similar to the Venezuela-US case, but there was an attempt there to go for uncitral, even though ICSID was referred to, so a shift in forum in that sense. In Crederi and in Hameson, the tribunal said you cannot do this, not even based on MFN. In Crederi, it was a case more similar to the Garanti case, so the kind of UK model BIT situation. And the question there was, even though uncitral is the default, can claimant move to ICSID? And then the tribunal said yes, based on MFN. Now, the way I make sense out of these two cases is that much depended on the wording of the MFN clause in those two cases. Those cases were MFN cases. For the Hameson tribunal, the MFN clause there was, in their view, relatively limited. I think in Crederi, it's clear the MFN clause is broader. The question here is, if ever this case becomes one of MFN, how broad is the MFN clause in this dispute? And in my view, it's a pretty broad MFN clause, areas related to MFN. It's perhaps not as broad as the one in Crederi, but the way I read it, it's definitely broader than the one in Hameson. And remember, in this case, MFN is just to confirm uncitral, which is already explicitly mentioned in the treaty and was explicitly agreed upon by the parties in their correspondence. So in conclusion, upon my assessment, the DR has expressed state consent pursuant to Article 13 of the treaty. The default rule in Article 13, combined with the correspondence. And then if there is a doubt left, the MFN clause confirms that because the DR later on gave more favorable treatment to French investments, that confirms through MFN, the claimant here should also get that more favorable treatment. That is, no doubt, no requirement of an ex post consent requirement for specific cases. Thank you, Chair.
Thank you. I think we can go directly to cross-examination unless you have any other proposals. Please go ahead.
Muchas gracias, señor presidente. Buenos días.
Thank you very much, Mr. Chairman. Good morning, dear colleagues, members of the tribunal. Yes? Do you hear me? This is the English channel.
¿Puedo?
May I proceed? Do you hear the interpretation? Are you hearing the English channel? Thank you. Good morning, Professor Paulin. My name is Gabriela Alvarez. I'm an associate at Curtis. I represent the Dominican Republic in this case, and I will have the pleasure of talking to you this morning. In the framework of what our colleague Richard Lorenzo said yesterday, our role is to do zealous advocacy. So the first part of my question is within that function, and the second part.
Okay, then I'll need the. I just want to be
In Spanish. Quiero.
Y después.
And further on, we will have a very interesting discussion on Article 13, obviously. So first of all, on the basis of what you describe in your curriculum vitae, it could be concluded that your professional and academic life has been dedicated significantly to aspects of international commercial law, mainly. Is that the case?
Well, at the Graduate Institute, we pride ourselves to be generalist, public international law, and then we specialize in some sub-areas, yes. International economic law.
Perfecto, gracias.
Thank you very much. And the majority of your publications have to do with issues of international trade law and public international law. Is that the case?
I have published also on trade law, general international law, and investment law, yes.
¿En cuántos?
In how many investment cases have you taken part as an expert, apart from this one?
First expert appearance.
Bienvenido.
Welcome.
¿Y cuántos arbitrajes de inversión como abogado?
And how many investment treaties have you taken part as a lawyer, as counsel?
5 cases.
¿Y
And how many of those have been under the exit agreement?
Agreement, I think the majority of them, yes. 4, yeah.
alguno de
Have any of them been under the UNCITRAL Convention?
Them was, yes, I'm sorry.
en eso?
In those arbitrations, did you represent the investor?
Then the investor, yes.
En todos ellos.
In all of them?
Los miembros.
The members of this tribunal are very experienced in investment arbitration under treaties. Is that the case?
¿Cree que su opinión pueda ayudar?
Why do you think your opinion can help the tribunal if the arbitrators have a lot of relevant experience in the interpretation of Article 13?
The more opinions, the better. I think it's good to take this seriously and provide objective analysis to hopefully help the tribunal.
¿Por qué cree?
Why do you believe that the respondent would have to present an expert opinion to refute your reports.
Whether you have to submit an expert opinion, that is your call. That I don't. That's not my.
Maybe I will put the question in English because maybe it was not properly translated. My question is, in your report in rebuttal, paragraph 3, you mentioned that, unfortunately, we didn't submit an expert report. Why do you think we should have had presented one?
Honestly, this is your call to make. I don't have any views on this.
Can you read what you state in paragraph 3?
In
Rebuttal.
C21, C131, okay.
Ahí indicó que
There you stated that the arguments of the claimant or the respondent are only based on arguments by the lawyers and that we did not present an expert report. Is that the case? Please proceed.
So can I repeat my answer?
We have an incomplete question on
Okay,
the
I'm sorry.
cut off the interpretation. So please ask the question again.
sí.
Mr. Chairman,
Let us know.
and I apologize for the interruption. Perhaps if the professor can keep the headphones on and allow the translation to work its way through the headphone, there will avoid the interruption with La Doctora Alvarez. I apologize for the interruption, just a suggestion that might help
It's
the
pertinent.
record.
Thank you.
My question is, if you felt the need to point out that there had not been a reply on the part of the Dominican Republic together with an expert report, is that the case?
If you read paragraph 3, it's a factual statement that in the rebuttal I was given your memorial on objections and not any expert report. It's a factual statement.
Entonces, ¿usted cree que
So you believe that part of the role of a legal expert is to go beyond an interpretation of the treaty and to involve factual confirmations in this case?
That is important to highlight here is that I was contacted to write the opinion in October 2018, at which point the details, the memorial on jurisdiction by the state was not yet available. So I wrote my expert opinion based on the evidence, the treaty, all the elements, the correspondence that was given to me. The state filed its memorial in January 2019, which of course provided a lot more in terms of your views, and I was then asked to write a response to that, because the first report was based on very limited arguments on behalf of the state. And what paragraph 3 says is just setting out the elements that have come in after I wrote my first report, and that included your memorial, but no legal expert opinion or fact or other elements that I was asked to look at. I just wanted to be very clear, as I did in my first report, on what basis am I writing my expert opinion.
Una duda que me surgió.
I have a doubt. Do you know why your your legal opinion is marked as a factual appendix?
To ask claimant.
Muy bien, gracias.
Thank you very much. In your curriculum, you say that you can read and understand Spanish. Did you have any problem to read the memorials of the DR, including the reply, which was in Spanish? Did you have it?
To read that, yes.
I'm sorry, repeat your answer?
Yes, I was able to read this.
Entonces,
So the position of the DR regarding Article 13 was clear in your mind, was it not?
Based on the submissions, so I did, for my rebuttal report, I had the memorial on jurisdiction that you had submitted in front of me.
y posteriormente usted tuvo.
And afterwards, were you able to read the reply?
Recently, I was given also the other submissions by the parties, the counter memorial by claimant, and then the DR's reply and the rejoinder. Yes.
¿Sabe usted por qué no? ¿Por qué más bien?
Why didn't you submit a third report to refute or rebut the rejoinder?
I was not asked to write a third report.
¿Puede?
Can you write in Spanish?
¿Cree que su análisis de la
Do you believe the analysis of the Spanish version of Article 13 could give elements to the members of the tribunal when it is the case that two of them speak Spanish?
Two versions are equally authentic, and Article 13 is not a long provision. I read it very carefully in both languages. The only difference, as I pointed out, that I found was the comma. Comma is the same in English, Spanish, so I didn't have any problem there.
No, mi pregunta no es si.
Well, my question is not whether you had a problem there, but whether the analysis of the comma in the Spanish version can provide elements of decision for Spanish speakers.
Mother tongue is Dutch, not English. So I'm doing my best to speak several languages, and my English happens to be better than my Spanish. And my analysis is one of law. I don't think, I mean, an element of it is language, you're right. But I will definitely not be any better in grammar than native English speaker, member of the tribunal, nor in Spanish than the Spanish, native Spanish speakers.
Entonces está de acuerdo conmigo.
So you agree with me that your analysis does not carry a lot of weight from the point of view of the Spanish language for the members of the tribunal who are experienced and are native Spanish speakers.
An assessment that I leave to them.
Perfecto. Yo también.
I do too.
Entre la pregunta y la respuesta.
Please pause between the question and the answer to receive the complete interpretation, if you may. When were you hired for this case?
I received an email on the 10th of October 2018.
¿Y cuál fue la
And what were your instructions by the counsel of the claimant regarding Article 13 of Annex 3?
Based on the evidence that they provided me, the treaty, and then later I asked for correspondence and all other documents, whether the state had consented.
Entonces, los abogados del demandante.
So the counsel of the claimant asked you to review the correspondence as part of your analysis, right? Could you please go to tab number 4? This has Appendix 1 to your first report. Did you write this list, this correspondence list?
So one of the requests I made was to get the correspondence to see whether there was any agreement on number of arbitrators or on the UNCITRAL rules. And I received one long PDF document from counsel for claimant, which included all of these letters. And then I had a student of mine make the actual annex, but that's the only input I got from the outside. Someone to help me write this rather long, detailed annex. You're right.
Cuando usted se refiere.
When you, in your reports, refer to the correspondence between the parties, are you referring only to the correspondence that is listed right here? Is that the case?
And there's a couple of other letters that I mentioned in the exhibit list as well. So for example, so the list you showed me is Exhibit 1 to my first report, and then there's for example, also an email in Exhibit 57, so I received some other elements as well. Or I was given other elements as well and reviewed those as well and annexed everything that I was given, that I supported my report on in my list of exhibits.
Entonces, aparte de esta lista.
So apart from this list, I just want to confirm I understood correctly. There are other exhibits that are also listed in your reports and which form part of a universe you considered in order to interpret the correspondence between the parties. Is that the case?
All the correspondence I relied on, I looked at, is listed here.
Perfecto.
Yeah.
Very well. Just to confirm, I understand you also read the 3 memorials of the claimant in this case. Is that right?
Read them.
Noto.
Did you observe that these memorials have a verbatim transcription of the arguments that you submit in your 2 reports?
I was happy to see that.
Perfecto.
Very well. Going back to paragraph 3 of your rebuttal, you confirm that the response of the respondent is only based on arguments created and submitted by its counsel. Is that the case?
I looked at your memorial to find out what the state's position was, to then write my rebuttal. Yes. Given that there was no expert opinion or other factual witnesses, I wanted to point out on what basis did I write a second report.
¿Y no le parece?
And don't you believe that what counsel did is precisely the role that a lawyer has to fulfill, which is to explain the legal arguments supporting the position of their client on the basis on jurisprudence and other arbitration cases or the International Court of Justice and other fora?
My job, I have been retained as an expert. I know this is a very different function compared to advocating. So I wrote my reports very carefully. I know we are being live streamed, so what I'm saying here is very carefully weighed and balanced as my own expert opinion. I'm not advocating anyone's opinion here.
Creo que esa no fue mi pregunta, pero entiendo su punto.
That was not the question, but I understand your reply. In paragraph 3 of your rebuttal, you say that the respondent submitted, and I quote, limited rebuttal arguments and materials commenting on my findings and conclusions. Is that the case?
Yes, that's what paragraph 3 says, indeed.
Usted,
You criticize the reply by the DR, but in the end, that is what you criticize in your rebuttal. In other words, you didn't contest all the arguments submitted by the Republic. Is that right?
I found it incredibly important to do I was very glad to be able to do a rebuttal, because my first report was written without your arguments in mind. And the rebuttal I wrote, I could finally see what the other side was saying. At first I only had that side. And based on your memorial, I thought it was useful to do a rebuttal and to complete my analysis in the first report based on what you have said.
esa no fue mi pregunta.
That was not the question.
Una pequeña diferencia.
I'm following the translation into English. Maybe you could state the question once again. Or maybe ask it in English.
That we provided limited rebuttal arguments and materials when we commented on your expert report, but you actually did the same in your rebuttal, in your report in rebuttal, because you didn't answer all our arguments, correct?
So
Traté de examinar todos sus...
Sorry, just a second. Interpreter, switch a channel, please. Start the answer again.
all of the arguments you made and those that, to me, added new light on the case, I engaged in and I elaborated my opinion based on those. But you're right, I didn't think my role was as an advocate where I would have to respond to each and every point you made. I was looking for elements that I may have missed to complete my expert opinion, not to take one or the other side or position or defend the other side.
Where then, if you thought that you were just given an objective opinion with no role whatsoever as an advocate, what do you use words like respondent speculates, respondent's arguments in these respects are not convincing, highly questionable, and ideologically charged, then backtracks, respondent backtracks? That's usually words that will be used by an advocate in zealous advocacy, I would say.
Well, that was definitely not the purpose. I was engaging with a document that heavily criticized my expert report and was responding to it.
Let's just look at a very telling, I would say, example. Turn to paragraph 22 of your rebuttal report. There, you said, respondent goes at great lengths to try to distinguish the CARICOM-Costa Rica Treaty, which respondent admits provides for ex ante consent to uncitral arbitration from the present treaty, correct?
Yes.
And then you point to paragraph 75 of our memorial, correct?
Mm-hmm. Yes.
So, turn to tab 5, please. It's paragraph 75 of our memorial. You will have highlighted in that paragraph sections in which we refer to that treaty. Can you just identify for me how we went into great lengths to distinguish it? Because I couldn't find it.
Well, the argument, and I would need time to read the whole submission again, but the argument was that the Costa Rica Treaty includes ex-ante state consent, and in the state's view, this was explained by a major change in the CARICOM Treaty, and there's a whole elaboration on why the revised Treaty of Guanamares has an impact on how CARICOM concludes treaties. So that is what I was referring to. That there was a whole debate trying to distinguish the two treaties, Costa Rica and the DR treaty.
But what did you said here we went at great length
Yes.
to distinguish that one had consent and the other no, but that was not the topic, right? Actually, we were talking about the circumstances of conclusion, and we just mentioned once, actually, or twice at the most.
Objection, argumentative. Is there a question for him?
Well, he's explained something, and I'm just telling him, well, why you don't read it? Tell me how many times we actually said that this is a clear consent, full stop.
No, but
And how,
Objection. Is there a question here, Mr. Chairman?
yes?
There is. Please,
so,
answer the question.
so
If-
perhaps there's a misunderstanding as to what paragraph 22 in my rebuttal refers to. So, in my view, the state spent quite a bit of time trying to distinguish the two treaties. Right? There's in many paragraphs a debate as to the Costa Rica Treaty and the DR Treaty. The debate, the great length, is not about the distinction on whether there's ex-ante consent or not. It's about the story about the Costa Rica Treaty happening after the revision within CARICOM and the DR Treaty happening before. That is the whole discussion. That is elaborated in your submission. So you're right, I don't think there was any great length discussion as to whether there's ex-ante consent or not.
So you are correct in what you said in paragraph 22, correct?
No, I think my paragraph is exactly what I'm saying now. because going at great lengths refers to distinguish the Costa Rica Treaty.
But
and then in brackets I have, which respondent admits provides for ex ante consent to uncitral arbitration. The distinction you were making referred to what I just mentioned, that one came after the revision of CARICOM and the other one was before.
But the next sentence in that paragraph in your report says, however, the only material difference between these two treaties on the question of consent is that the present treaty only offers ex ante consent to uncitral arbitration. The Costa Rica Treaty offers consent to both uncitral arbitration as well as ICSID.
Yes, that is my view.
Yeah, but you were talking about consent, not the circumstances of the signature of the two treaties.
No,
correct? In this paragraph.
Yes, to me that is the only big difference. The language, one referring to ICSID, the other one not, between the two treaties. And I don't see any relevance related to the revision of the CARICOM Treaty. And that I explain in another paragraph.
So that's the only material difference, in your view, between the Costa Rica Treaty and our treaty?
Now that one refers to ICSID, the other one doesn't, and the distinction that you highlighted in your submission, the element of the revised Treaty of CARICOM, to me that had no impact or was not relevant here because the revision didn't really give any more powers to CARICOM to do ex ante or ex post consent.
But you were talking about the texts of the two treaties and how they were different. And you said, or similar to one to the other. And you said between the two, the only difference is basically that one doesn't refer to ICSID and the other does refer to ICSID, correct?
Yes.
Okay. Let's turn to tab 13. That's the Costa Rica Treaty. You will have it first in English, then in Spanish, and then you have at the end a slide that we used at the opening. And that compares both treaties. Just at first glance, would you say that that's the only material difference?
Okay, so let me read what I said in my rebuttal. The only material difference between these two treaties on the question of consent is that the present treaty only offers ex ante consent to uncitral. The Costa Rica Treaty offers consent to both uncitral as well as ICSID and ICSID additional facility. So the bottom line, when I analyze, okay, what kind of consent is provided here, in my view, both are ex ante, but the difference, material difference, bottom line difference is that in Costa Rica, it not only refers to uncitral, but also to ICSID and ICSID additional facility. And then I explain, well, the reason for that is clear because the DR is not an ICSID party.
But the texts are pretty different,
yes.
Correct?
So yeah, there's the textual, there's a lot of words that are different, but the bottom line, the material difference is what I just explained, in my view.
Let's, I think, I don't know. How much time is left?
Sí, llevan 35 minutos.
Let's just turn to.
I'm sorry.
You've used 35 minutes.
We used 35 minutes.
Now I have cracking in my ear, and that's it. Oh, no.
Just a few words about the preparatory works. Can you turn to tab 6, please? No, 6. You confirm in your opening presentation that you have read the preparatory works. Can you look at this first document and tell me whether in Article 10, what was said in paragraph 10? What the parties in this treaty were foreseen at that point in time as to investment disputes?
So should I read the provision? You want me to?
If you want to read it, my question is, do you see anything that tells you that the parties were discussing investment arbitration at this point?
Yeah, so they want to encourage investments, and they refer to potential negotiations of bilateral investment treaties.
There's no mention of investment dispute resolutions, correct?
Right, so from what I understand, this was added later on, actually at the request of CARICOM.
Are you referring to, then turn to
Yes.
tab 8, I think you're referring to tab 8, correct?
Yes. Which I found very interesting.
Let me ask you
Yes.
something. Would you say that this provision would look similar, not the same, but similar to the alternative UK model BIT?
Where is the alternative UK model BIT?
It's in tab 9, if you turn.
Okay.
I suppose you are familiar with it, right? Because
Yes.
you mentioned it.
Yep. So what is your question?
My question was whether you think they are similar, not the same, but similar.
I do think there's quite a number of differences in that ICC is not referred to, and there is no.
Sorry, you meant ICSID, right?
No, ICC.
ICC, yeah,
Yes.
ICC. Mhm.
So, in the what you call the UK alternative, you have ABC, and in the earlier version of this treaty, you have A and B only.
And would be another difference that in the UK model BIT, you have a default provision.
Absolutely.
Okay, now let's turn to Article 13. We will put Article 13 on the screen just because I'm sure we will need to refer to it. And maybe now I will turn to Spanish because I think that would be more helpful.
The position of the Dominican Republic with regards to the meaning of paragraph 1 of Article 13 is that it does not contain consent to international arbitration nor to uncitral arbitration. Is this correct?
Your position, yes.
Let us look at paragraphs 13 and 14 of your rebuttal report. Here, first, towards the end of paragraph 13 in your report, your rebuttal report, you refer to paragraph 1 of Article 13 and you say,
opts for international arbitration as claimant did in this case, Article 13, paragraph 1 unequivocally confirms respondents' ex ante consent to such arbitration. Y luego,
and then immediately following that in next paragraph you say,
agrees with this. Y se refiere al párrafo.
And you're referring to paragraph 45 of the jurisdictional memorial of the respondent. Is that correct?
Yes.
This assertion you made is incorrect. Is that true?
No, let me explain. I thought when I answered that your position is that there's no state consent in paragraph 1, I was referring to what you explained yesterday. But in para 14, I refer to a statement you made, the DR made, in its jurisdictional memorial, which I thought was very interesting. But from what I understand, you have retracted. You have changed your view on this.
Veamos eso.
Let us look into that.
Yes.
Let us look into that. Please refer to the memorial. It's under tab 5. The first part, which is the one that you cite, could you please tell me where we say that the DR consented to international arbitration in this first part, and obviously you omitted the next portion also, but where in this first part that you cite do we say that the DR consented to international arbitration?
So the way I was reading that statement is that you look at Article 13, paragraph 1, and you find in there, accepta en principio.
Accept in principle.
So accept in principle that disputes shall be submitted to the 3 options, which I think is a correct statement. There is a consent.
Pero nosotros no dijimos eso.
But we didn't say that.
Overlapping between the questions from Respondents' Counsel and the expert, perhaps they should be instructed to just
please don't
wait a little
interrupt
bit.
for that. I think if we have some problem for transcription, we will repeat to ask for the repetition of the question. I think it's until now it's correct. We can keep like this. Please just wait for at the end of the answer before make a new question.
Thank you.
If you want, I can reformulate my question. Could you please tell me? It is true that we said that, in principle, there is acceptance of the 3 options, that being national tribunals, national arbitration, or international arbitration. That is there. My question is, where do we find the consent of the DR to international arbitration that you see in this part of the memorial?
So when I read paragraph 45, then it says the first paragraph of Article 13, defines the scope of application of the disputes covered, and then it says, and I quote here, y acepta in principio que las...
And in principle accepts that the disputes having to do to an obligation under the treaty shall be remitted either to national tribunals, national arbitration, or international arbitration.
It's on that basis that I was just reading that this, in your view also, means an acceptance in principle of the three options, which I don't think is... That's what the text says.
Perfecto. Sí,
Yes, fine. That's what the text says, is that in principle the three options are accepted. So we then correct your report where you say that we accept consent to international arbitration in principle, because that is not stated here. Is that correct?
Well, as I said in my opening statement in the summary of the reports, if I have an option to go to one place or an option to go to two or three, those are options. And having two or three options is better than one. If there's a or an o, to me, those are options. And you can go to any of the three. So when you say you accept in principle that they can be submitted either to A, B, or C, to me that means you have accepted that the investor can submit them to A, B, or C.
Estamos de acuerdo.
We agree on that principle. My question, well, that's actually not what you say in this paragraph 14 of your report. You said that we had accepted what you said earlier, which was consent to international arbitration. My question is whether you wish to amend that statement and say that the acceptance was that they will be submitted either to international arbitration or national arbitration or national tribunals.
But arbitraje internacional is mentioned.
Como una de las opciones,
Yes.
correcto.
Yes, that's one of the options. Is that correct?
Or an open door. Those are the three options available. Or you...
My problem is what you say in your paragraph 14, and not only in 14. But let me clarify that what you're saying refers also to the end of paragraph 13. In other words, is that what you're saying? In your reading, you're saying that paragraph 14 confirms what is stated at the end of paragraph 13. Am I understanding you correctly? That's correct.
dropped the reference to national courts, national arbitration, and just put three dots, because there's an agreement to all three, and I wanted to quote the whole paragraph.
And perhaps also you should say ex ante consent. That should be changed. And it should just say shall be submitted. Because if we understand the full argument, and we have spent many hours on this here, they shall be submitted. Those words are the ones on which we have a different interpretation. Is this correct?
Less so in the submission, definitely more yesterday, yes. But all I do is quote the line from your submission.
Claro, la citó.
Yes, you quote it. But before quoting it, you characterized our section on the memorial as if we were saying that we agreed that that portion says that the DR confirmed that there was an ex ante consent to such arbitration. That is what you say in the last sentence of your paragraph 13. Is that correct? And that is the difference, where we have a discrepancy.
¿Cuál?
Hay un...
I'm still listening to the interpretation, and he's answering.
Mr.
Did you hear the issue? You need before Professor Pauling, before answering, please wait to the finish of the translation and the interpretation. So otherwise there is overlapping.
Mr. Chairman, perhaps it would help if the professor puts the earphones
Yeah, but
back on.
I
and then
understand
that would help with
that
the
he is not very
interpretation.
comfortable with that. That's I'm sorry. I didn't. I'm trying not to interrupt. And it's your cross-examination, but maybe we can sum up. Professor Pauling, you confirm what you said in paragraph 14 of your second expert report. You confirm that, or you prefer to change, or you accept that the view of respondent is more accurate, or something like this? You simply confirm or not?
I confirm, but I understand. I confirm. I believe, and stand by what I wrote here, but I understand your argument that you also have an issue around serán sometidas that you want to elaborate on. And I think I've heard this a lot more yesterday than in the brief. So I see your point.
You can live with. I understand that you are not in agreement, but you can live with this.
Yo pondría nada más para el récord.
Yes, but for the record, I just think we should mention this, but let's move on to the next issue. Thank you very much for your collaboration. I think we're now going to go into the most interesting part of the discussion. Article 13. In paragraph 36 of your first report, you assert that paragraph 1 of Article 13 expresses the DR's consent to international arbitration. Is this correct?
Yes.
And your interpretation is based on the verb será, shall, in Spanish, followed by the word sometida, and shall in English, and in English it's shall be submitted, giving both of them a meaning of obligation. Is this correct?
Yes.
Será es el verbo ser conjugado en futuro, ¿correcto?
Mm-hmm.
Shall is the verb to be conjugated in the future. Shall be. Is that correct?
¿Está de acuerdo?
Do you agree with me that this verb conjugated in the future denotes a future action, correct?
So when you sign a treaty like this or a dispute clause like this, you talk about disputes that may occur in the future. And when they occur in the future, they shall be submitted to. By the way, I was looking at the model clause proposed by UNCITRAL under the 1976 rules, and it says exactly that. Shall be settled by arbitration in accordance with. So if UNCITRAL gives that as the model language to follow, to have binding consent to arbitration, I don't know how much clearer you can make it. Shall be submitted. It's confirmed by UNCTAD that that kind of language is binding, shall be submitted, leaves no doubt as to the binding character of these clauses.
Veamos, de hecho, creo que es muy útil que usted haya referido.
And it's very useful that you mentioned the UNCITRAL rules, because they are in tab 19. And I think it's useful, before we start the discussion, to look at that. It's first in English and then it's in Spanish. Do you see before Article 1 the title of that section of the rules?
Exactamente. Ámbito de aplicación. Y el artículo 1.
Article 1.1 defines the scope of application of the rules of UNCITRAL. Tell me whether you are in agreement with me. Article 1.1 requires that parties shall be made an agreement, have agreed in writing that disputes in relation to the contract shall be referred to the arbitration under UNCITRAL in writing.
Ahora me voy a parar. Ay, pero si me paro no. No me van a oír. Pero
tell me whether. Oh, another question first. You would agree with me that when we talk about scope of application, that is a requirement which is material, substantive, to be able to use these rules. Can you tell me where in paragraph 1 you find a reference that will place you in the scope of arbitration demanded by the rules?
Referring to paragraph 1 of the treaty?
Sí, perdón. Párrafo 1 del artículo 13.
Paragraph 1 of Article 13.
UNCITRAL. So in paragraph 1, there is consent to international arbitration amongst the three options. And that's a choice of forum. This is a very important commitment. International arbitration is different from national arbitration, which I assume would be under the national law of the Dominican Republic in this case. And then paragraph 2 refers to UNCITRAL rules when it comes to the appointment of the arbitrators. And paragraph 3 and 4 continue talking about international arbitration. But I look at UNCITRAL as the procedural rules for mainly appointment of arbitrators. And the substantive commitment to international arbitration is under paragraph 1. So are we at UNCITRAL? UNCITRAL is not a forum, it's a set of rules. We are at ICSID, so that all depends on party agreement. But the reference to UNCITRAL required under the UNCITRAL rules that I see is in the treaty, paragraph 2, and equally importantly in your correspondence of May 2018.
Dijo muchas cosas en eso.
You said many things there, but let's go point by point. You said that the consent of the Republic is not to the UNCITRAL rules, because that is in paragraph 2. Where do you find the words that say that the party involved submitted or consented that their disputes be ruled by the UNCITRAL rules. Where is that consent in paragraph 2?
No, I didn't say anything. No. So the sequence that this provision sets up, and I think it's well constructed, is that if there's disputes that investors have with host states about treaty breach, the investor has 3 options, A, B, C. And then when the dispute is referred to international arbitration, so in the first paragraph, the options provided, in my view, they express a consent on behalf of the state that those 3 are available. You commit to those in paragraph 1. And then when it comes to the eventuality where the investor decides to go for international arbitration, paragraph 2 kicks in. And in the notice in this case, the claimant filed the case, suggesting a tribunal and relying on UNCITRAL rules 2010. Then we have the correspondence, which confirmed the tribunal option, not a sole arbitrator. And there was a quibble about 1976, 2010. So the correspondence is key. That is part of the agreement to UNCITRAL. As I said, even if you would have doubts about the correspondence, if you read paragraph 2, it refers to 2 options, special agreement or established under the rules of arbitration of UNCITRAL, without special agreement. To me, that is an ex ante consent to both international arbitration and to the UNCITRAL rules.
Entonces, el ex ante.
Therefore, ex ante consent that you see in the second paragraph is hidden where in the text, because it's not explicit. But I read your report and you said that it can be implicit. But if we say it's implicit, can you tell me exactly where in the text you identify as ex ante consent or anticipated consent to the UNCITRAL regulations in the text of the article? Can you tell me where that is? What words? What words?
Is referred to international arbitration. This is paragraph 2. The investor and the party concerned in the dispute may agree to refer the dispute to a sole arbitrator or ad hoc arbitration tribunal. And here it comes, to be appointed by a special agreement, and I have not seen any special agreement here, or established under the arbitration rules of UNCITRAL, without special agreement. Okay. So you're right, the word consent is not there, but as I said, and many tribunals, many commentators have, and I think it's kind of obvious, even UNCITRAL says, please use that model arbitration clause where the word consent is not mentioned. It says any dispute shall be settled by arbitration in accordance with the UNCITRAL arbitration rules. So if you're looking for the word consent, it's not there. But if you read para 1, paragraph 2, even without the actual word consent, there's an obligation, there's an acceptance by both CARICOM states and by the DR that if there is a dispute in respect of treaty breach, international arbitration is one of the 3 options available. And UNCITRAL is the fallback rule.
I am trying to follow your reasoning. Not that I am in agreement, but to be able to understand it. You say the word consent is not found in paragraph 2, but as in the Modelo clause, the word consent is not there, but it says shall be submitted in the model clause. Serán sometidas. So we don't need the word consent. In paragraph 2, where are the words shall be submitted o serán sometidas?
No, there's a sequence here. There's a very logical sequence. Shall be submitted is paragraph 1. Paragraph 2 starts out saying it is referred to now. And then the only discussion that is left is appointing arbitrators and whether there'll be special agreement or the UNCITRAL rules, which provide for 3 arbitrators by default.
Entonces,
Therefore, you say that they have to be read in sequence. Before I go on with that reasoning, let me ask you, why in paragraph 1, or paragraph 40, rather, of your first report, you say that paragraph 1 paragraph 2 of Article 13 is delinked from paragraph 1.
me confunde un poco eso, porque ahorita le estoy entendiendo.
That confuses me because I understand now that they have to be linked, in fact. Would you like to correct that part of your submission?
In paragraph 40 is that they are delinked and that there is a sequence. And I'm responding here to the position or the alternative reading that may agree in paragraph 2, that this may agree would also undermine the consent in paragraph 1. So what I'm saying is that paragraph 1 has the shall be submitted. And that's strong. Paragraph 2 is about appointing arbitrators, and there's may agree language on the numbers. But to read may agree as requiring a second consent on top of the one already given under paragraph 1, I think that would be against the shall be submitted. So in that sense, you need to separate the two. May agree refers to the number of arbitrators. May agree does not refer to submission to international arbitration, because paragraph 2 starts off saying that this has now happened. Cuando la controversia es referida.
When the dispute is referred to.
Su preocupación mayor es
Your main concern is that, because in your presentation that seems to show that's your main concern, you see inconsistency between shall be submitted, which we see in the first paragraph, and the may agree of the second paragraph. I would like to see whether you agree to this possibility that we read paragraph 1 in the following fashion. The disputes between an investor of one party and the other party shall be submitted, and we have 3 options, to national courts, national arbitration, or international arbitration. And at that moment, we say, what do? We have 3 options. What are we going to do with the 3 options? There's nothing said here about how to implement those options. Do you agree with me?
That's why you have to continue reading the second paragraph. I mean, if I may, and I don't know whether this is appropriate, but I'm trying to follow your reasoning.
No, pero,
let me.
Okay.
Interrumpo, le hace una cuestión.
I'd like to understand your point, but the analogy that I'm thinking of is, imagine you contract a travel insurance. Okay, so you travel from Geneva to Washington, and you have travel insurance in case you fall ill, right? And my travel insurance says, in case you fall ill in Washington, you as a patient, your illness shall be treated in hospital A, B, or C. Georgetown University Hospital, hospital B or C. And I'm the person insured here, I would read this to mean that my insurance will cover me whether I go to hospital A, B, or C. And I have the choice to go to A, B, or C. I don't have to call my insurance to double check whether I can go to A, B, and C. Paragraph 2 here then deals with, well, assume I opt for going to Georgetown University Hospital. And I think if that would be the text of my insurance, I would fully trust that they would pay for the bills. Paragraph 2 is about when I go to Georgetown University Hospital, which doctor will look at me? Who will treat my illness? Which is a secondary element in my, or following on or after my choice to go for option A. So there is a logical sequence, and I think A is the option chosen. Paragraph 1 is really important. Paragraph 2 is about which doctor will you get. 1, 3, appointed by the emergency unit of it. You go to Georgetown University Hospital.
Voy a seguir su ejemplo.
I follow your example. I follow your example and will make a parallel with our paragraph, and you give me your opinion. And it's interesting that I use the example of insurance. You buy an insurance and you know that you have those options. And in general, you have to read the clauses to see how to implement those options. Do you agree with me in that? In my reading, which is a possible reading, the 3 options talk about options that you have to see where to implement that and how, as happens in insurance. What clauses apply to me? If I go to national courts, I have to say what the national legislation says. What options does the national law give me? If I go to national arbitration, I have to see what national arbitration says. And if I go to international arbitration, they give me the answer in Article 2 or Paragraph 2. Paragraph 2 of Article 13 says what it is that I have to do for that option to be implemented. Do you agree with me on that premise, following your example of the insurance?
Yes, but the 3 options are not abstract in the air. They are very concrete. The courts of the Dominican Republic, national arbitration, or international arbitration. International arbitration has a deep meaning and can be triggered relatively easily, the main point being who will be the arbitrators, and then the provision continues about how the award is binding and what have you.
Siguiendo su razonamiento.
Following your reasoning, if an investor reads the 3 options that we have in paragraph 1 and says, Dr. Pauling, this is my arbitration notice. Paragraph 1 says national arbitration or international arbitration. Can you tell me? Because I don't know who it is that I have to submit this to. Do you have that answer in paragraph 1?
I see international arbitration in paragraph 1, and if I would be the investor, I would look at the 3 options. The way, if I have an accident in DC and I'm closest to Georgetown University Hospital, that's where I would go to. If I'm closer to another hospital, but it's not listed, I wouldn't go there unless I'm dying. But I have 3 options, and depending on, because those are cases by the investor against the state. It's about me falling ill. It has nothing to do with the other side. It's a one-way street. And then I would go to one of the options that I find most convenient to me. And in our situation here, you have a notice of arbitration, and you then start discussing 1 or 3 arbitrators, which rules will be applied. Those are the nuts and bolts of international arbitration.
Yo creo que
I think that the heart of the problem is that what you're telling me is that once you have the three options, although the first paragraph doesn't talk about how to implement the options, you jump to the second paragraph and you say we can start talking about the implementation details, such as the designation of arbiters. But the UNCITRAL rules, the designation of the arbiters begin in Article 5, correct? Number of arbitrators.
Entonces,
what you're telling me is paragraph 1 does not yet talk about Article 1. But in paragraph 1, from paragraph 1, we can jump to paragraph 2, and the first thing that we mention is Article 5 of the rules. We have not yet talked about Article 1. You're already in Article 5 when you have not yet met the requirements of Article 1. Is that correct?
No, the sequence is you opt for one of the three, and then you have a notice, and you see whether agreement can be reached on number of arbitrators or on special rules. And to me, based on paragraph 2, there's a bifurcation. Either you have special rules or the UNCITRAL default rules apply. That's exactly how the two co-arbitrators in this case put it to the parties. You have appointed us, so there's agreement to 3 members. Now the next question is, do we go for fallback UNCITRAL or do we have a special agreement? That's exactly what paragraph 2 says. There was no special agreement. Actually, I do think there's an agreement to UNCITRAL, 1976, after some discussion. But even in the absence of that, that's the default that paragraph 2 refers to. And you're right, then we are within the UNCITRAL rules in case they cannot agree on a sole or 3 members of the tribunal. In this case, they did agree to 3. They did agree. If they would not have been able to agree, imagine the DR would have not done anything. Then Article 5 says there'll be 3 members. And I forget which provision it is, but if the respondent doesn't appoint an arbitrator, then you have the PCA acting as designating appointing authority.
Creo que me está dando la razón, es decir, usted...
I think you're saying that I'm right. You go from paragraph 1, which gives you 3 options, to the implementing of one of those options directly when you designate arbiters. Is that correct?
Yes, paragraph 2 is about one of the options. It's only about international arbitration. Right? Yeah.
And the objective of paragraph 2 is to decide on procedural issues that derive from Article 5 from UNCITRAL rules. They are governed by Article 5 of UNCITRAL and the following rules of the UNCITRAL rules.
No, you first have to be within the UNCITRAL rules, and that's the agreement that they've expressed in correspondence. And even if there wouldn't be a special agreement, it's the fallback, it's the only rules that paragraph 2 refers to.
Entonces,
and then that gets you to Article 5. You're right.
But you say then that may agree to submit or to refer, may agree to refer is talking about the arbiters, but we're still not under UNCITRAL arbitration. Is that correct?
The second part of paragraph 2 on my reading, is the may agree language. It just gives you the option, go for 1 or 3. That's up to you. You may agree, you may not agree. There's nothing says must agree or shall agree or second consent required. It's about numbers. And then the third part is crucial because that talks about the rules that will be applied for appointment, either by special agreement or the UNCITRAL rules.
Entonces, la última parte es para saber cómo se van a nombrar.
The last part, therefore, is to see how arbiters will be designated under a special agreement or as established by the UNCITRAL rules?
It refers to the tribunal rules, yes.
Es procesal.
So it's procedural, correct?
UNCITRAL rules are about appointment of arbitrators, proceedings, and the eventual award, yes.
Excepto
except paragraph 1, which is the scope of application. Article 1 of the UNCITRAL rules has to do with the substantive scope of application. Is that correct?
Yes, and I had that on one of my slides as well. You need, before you're in UNCITRAL rules, you need agreement in writing. And I repeat, the agreement in writing to me is in 2 places, party correspondence and in paragraph 2.
Dígame, cuando usted habla de la correspondencia.
When you talk about the correspondence between the parties, when you talk about correspondence between the parties, and you refer to Article 1, did you find any correspondence where the Dominican Republic consented to submit to UNCITRAL arbitration in keeping with Article 1?
To me, the 2 crucial pieces of correspondence are the email of 18th of May with a letter attached, which goes to appointment of an arbitrator, C-133. And another one is a letter by the Dominican Republic to the PCA where they say it's not UNCITRAL 2010, but UNCITRAL 1976. That should apply in this case.
Esa correspondencia.
That correspondence referred to the type or the version of the UNCITRAL rules for procedural effects. Is that correct?
So it's exactly the kind of procedural confirmation that is referred to in paragraph 2. As I said earlier, to me, the substantive, the major commitment is in paragraph 1. That is a commitment to be subjected to international arbitration. So I'm not saying that the letter or the correspondence in and of itself represents state consent. It's the complement referred to under paragraph 2. The letter with paragraph 1 is the whole package.
Es decir, usted para poder.
So to be able to read the shall be submitted to UNCITRAL rules, on the one hand, you have to use shall be submitted to international arbitration in paragraph 1 and then paste it with the correspondence that talks about the version of the rules.
Yes, and that is why in one of my early slides I refer to the principle that you can consent to arbitration, like in any contractual setting, through a variety of documents. I mean, the whole basis of investor-state arbitration is the state consents in a treaty, and then the investor consents in another document by filing a notice of arbitration. That is pasting 2 documents, and here it's no different. It's pasting para 1 with para 2 and the correspondence, which completes the state consent.
Dígame una cosa. Sí.
Tell me one thing. If we follow your reasoning, with which I disagree, but if we follow it, then Mr. Lishin had a sort of vision that this debate was going to happen, and that's why he submitted his notice of arbitration before the correspondence was drafted? Or how do you think that this procedure happened for the decision making?
I have no idea of motivations behind it, but what I see is a notice of arbitration. I see very cooperative emails, correspondence, honest discussions about arbitrators, either side appointing, a discussion of UNCITRAL 2010-76. And then, to be honest, there's a major shift as of the email of 6th of June, where the Dominican Republic changes tone and says we have appointed counsel, and all of a sudden there's a change in tone and opinion, and there's objections to everything. So in my view, by then it's too late. The party correspondence preceding 6th of June has happened, and I don't think there's any ploy or clever move behind it. That's, if you read the treaty and you have an investor case, that's what you do. You reach out to the state. The notice of arbitration needs to be filed, and then there's 3 months provided for under the treaty. And those, in my view and in my experience, those 3 months are there to hopefully find a settlement, avoid all of this, and talk about, if it moves forward to international arbitration, talk about UNCITRAL, special agreement. That's how it normally goes.
Le voy a hacer una pregunta.
Let me ask you a hypothetical, because now we have 3 versions of the UNCITRAL rules. But let's say
Concentrarse.
you only have 5 minutes. Let's say that we didn't have the other 2 rules. Wouldn't we have had the procedural discussion on the type of rules, because there would only be one, so there wouldn't have been an exchange between the parties regarding whether they had to accept the 2010 version proposed by the claimant, or whether the rules applicable were those of 1976. If we hadn't had that correspondence, there wouldn't have been, as you say, the other part that was missing in Article 1. Is that correct? Of paragraph 1 of Article 13. Is that correct?
The discussion on which of the versions of UNCITRAL rules applies is an important one. And there as well, there's a fallback. If there's no special agreement, if there's no meeting of the conditions for the rules 2013. So in my report, I explain all of it in paragraph 54. And in my view, you were correct. It's 1976 that applies.
If we are in the fallback position, as you call it, which is in the last sentence of paragraph 2, established under the arbitration rules of UNCITRAL, for what you're saying to take place, we would have to read the default in what part of paragraph 2? In other words, where do those words appear? By default, where the words by default, where are they in paragraph 2?
Like the debate we've had on consent, the word default is not there, right? But a good faith reading of the last part refers to two options. And it's also the reading that the co-arbitrators put in their email to you. Is there a special agreement? Tell us, is there a special agreement? Or will the UNCITRAL rules apply? So it's acuerdo especial, or, so the other option doesn't require a special agreement established under the UNCITRAL rules.
Una pregunta respecto a eso. Usted...
A question on that. You say that they could agree due to the effect of the comma, and that wouldn't apply to the second part of the paragraph. Is that right?
Refers to the number of arbitrators, right? Now, the way I understand your reading of this is that may agree goes as far as the third part and covers also acuerdo especial, which I don't think makes sense. If you have may agree, special agreement, it duplicates. And you would even extend it as far as may agree to UNCITRAL rules. And that is, I think, the crux of that. There I have a completely different reading. May agree is limited to number of arbitrators. And the third part is, again, special agreement or UNCITRAL. So may agree doesn't apply to UNCITRAL.
Y usted lee...
And you read this special agreement part in two ways. To be named by special agreement has to do with the number of arbitrators, or the parties may agree a special agreement regarding the type of rules. It could be the ICC rules, or etc.
So it refers to how you will appoint arbitrators and the rules of the tribunal. Special agreement or UNCITRAL.
Y entonces ahí...
And then may agree right there also refers to special agreement. They could agree through a special agreement, or they may agree through a special agreement. So the special agreement refers to the rules. It could agree to follow arbitration through a set of other rules, right?
So may agree means you have the option. You may agree on special rules, or you may agree on a sole arbitrator. But if not, it's UNCITRAL.
Okay.
So that's why I think your reading reads may agree as must agree a second time. It doesn't say must agree. It says it's purely optional. May agree to one or three.
En eso estamos de acuerdo. Nosotros creemos.
We agree on that. We believe that it's may agree, not must agree. But when you say they may agree on a special agreement on rules, the comma after special agreement is displaced because this applies to the special agreement, the podrán acordar, right?
That refers to sole arbitrator or a tribunal. And then there's the comma, and then it goes on about the rules, special agreement, or UNCITRAL. So to me, it's very logical, and the comma serves its purpose.
Ya no tengo más preguntas.
No further questions. In any case, you had reached the end of your time allotted. We will go into a recess. I think we all deserve a break, particularly the expert. And we will reconvene in 15 minutes in order to...
Again, for the eventual questions from the arbitral tribunal.